The Supreme Court heard oral arguments in the key transgender case U.S. v. Skrmetti Wednesday, and the people arguing for transgender chemical castrations for minors told quite a few whoppers. Here's the Daily Signal roundup of the lies. First, Biden administration lawyer Elizabeth Prologer claimed that drugs that stop the effects of puberty, so-called puberty blockers, are fully reversible.
Puberty blockers, which is just pressing pause on someone's endogenous puberty to give them more time to understand their identity.
Yet Dr. Paul Hrues, a hormone doctor, has written that patients can't just turn back the clock after pubertal suppression.
The temporal process and the link between the biological changes of puberty occur at the time of adolescence. And because one is interrupting this normal developmental process, that time element cannot be replaced.
And neurologist Dr. Sophie Scott warned that puberty blockers can affect brain development. Second, ACLU lawyer Chase Strangio claimed that it is clearly established in the science that chemical castration drugs reduce the risk of depression, anxiety, and suicidality.
I do, Justice Alito, maintain that the medications in question reduce the risk of depression, anxiety, and suicidality, which are all indicators of potential suicide.
And do you think that's clearly established? Do you think there's reason for disagreement about that?
I do think it is clearly established in the science and in the record.
Yet even an FDA official who supports puberty blockers admitted in an email that the FDA's research found increased thoughts of suicide among minors who took puberty blockers. Third, Prologer suggested that children going through puberty is itself harmful. Her argument flips the natural course of biology on its head. She's actually calling for gender-confused kids to undergo a chemically induced facsimile of the opposite sex's puberty, as if that were more healthy than what the body does on its own.
If you're thinking about this from the standpoint of there's no harm in just making them wait until they're adults, I think you have to recognize that the effect of denying this care is to produce irreversible physical effects that are consistent with their birth sex, because they have to go through puberty before they turn 18. So essentially what this law is doing is saying we're going to make all adolescents in the state develop the physical secondary sex characteristics consistent with their gender or with their sex assigned at birth, even though that might significantly worsen gender dysphoria, increase the risk of suicide, and I think critically make it much harder to live and be accepted in their gender identity as an adult.
Fourth, Justices Sonia Sotomayor and Ketanji Brown-Jackson suggested that it is the same thing for boys who experience puberty too early to take puberty blockers, and for girls who want to appear like boys to take puberty blockers in order to stop their natural puberty.
The boy comes in, he asks for a hormone treatment to deepen his voice, to affirm his masculinity. Can he get the treatment? With respect to consistency, he could.
Under this statute, he could.
Okay.
Under 63-6-214-12, he could not.
I understand. Setting aside that other statute, under this statute, he could. Now, looking at this statute, a girl comes in biologically and asks for a hormone to deepen her voice in order to affirm the identity that she chooses, which is masculinity.
Your Honor, I think if it's for the purpose of identifying inconsistent with their sex, she would be barred from doing that.
Tennessee Solicitor General Matt Rice set the record straight, pointing out that these are addressing two entirely different problems.
The only way that my friends can point to a sex-based line is to conflate the use of puberty blockers to address precocious puberty with the use of puberty blockers to transition, and those are fundamentally different treatments. They have different effects on the body. They're used for different purposes.
Justice Elena Kagan argued that Tennessee's law aims to encourage gender conformity.
But one of the articulated purposes of this law is essentially to encourage gender conformity and to discourage anything other than gender conformity. And I'm wondering how you think that plays into the analysis.
I disagree with that characterization of our law.
Encourage minors to appreciate their sex and ban treatments that might encourage minors to become disdainful of their sex. Sounds to me like we want boys to be boys and we want girls to be girls.
In reality, it is the transgender movement itself that pushes gender conformity by claiming that boys who are interested in girl things are really girls, regardless of their biology. Rice noted that Tennessee wanted to ban medical experiments in part because they would cause minors to become disdainful of their sex, rejecting their own biology, and experiencing harm as a result.
The appreciate their sex reference detailed in legislative findings, that is simply the recognition that given the high desistance rate among minors and given the tragic regret of detransitioners, that there is an interest in making sure that minors have enough time to appreciate their sex before undergoing life-altering changes. So I think that that has to be viewed in the context of the legislative findings, which both emphasize the detransitioners and the high rate of desistance. With respect to become disdainful of their sex, the challengers have never explained why it would be problematic to prevent interventions that could affirmatively cause minors to become disdainful of their sex and thus at issue for psychiatric conditions. And in fact, there are multiple studies, I would point to this court, JA 400, where minors actually, their mental health and suicidality got worse after taking these interventions.
Finally, in perhaps the most shocking comparison, Justice Jackson said Tennessee's law protecting kids from chemical castration and genital mutilation is the exact same sort of thing as laws prohibiting interracial marriage.
Didn't we already dispose of that kind of reasoning with our equal protection cases that looked at things like interracial marriage, where we said, even though it applies to both, it's still making a racial classification? Even though whites can't marry non-whites and non-whites can't marry whites in the statute, right? So both are equally disadvantaged. We said that's not an argument for why you shouldn't have a heightened scrutiny or why the statute is not making a race-based classification.
Matt Rice set the record straight, as if it needed to be done.
And that's not the argument that we're making,
Okay,
Your Honor.
so what is
We are
your
not arguing that you can discriminate and draw lines so long as you do so both against boys and against girls. We're arguing there is no sex-based line. If you're a boy and you go in to get puberty blockers, you can get the puberty blockers if you're going to use them for precocious puberty. You cannot get the puberty blockers if you're going to use them to transition. That is not a sex-based line. That is a purpose-based line. So our fundamental point here is not that you can discriminate against both sexes in equal degree. Our fundamental point is there is no sex-based line here, and the only way to get to a sex-based line is by equating fundamentally different treatments that defy medical reality and defy how the statute itself sets out what is a treatment.